your old buddy Brian Parker coming at you with a new video. I'm on the side so I can present everything here that I need you to see. I just did a 5-part video on examining the collection lawsuit. And what I'm going to do today is apply the practical terms from that video and show you through a new kind of entity I haven't done before. It's called S&D Investors, LLC, whatever. They're all the same. They're all debt buyers buying bad debt in a bad way, filing bad lawsuits, bad. So, what I introduced in that video, let's put it up. There's the 5 parts. I think I did that 5 times. There are the 5 parts, swish. And the first one is I did something that I felt like I neglected not analyzing for you previously. The summons. The summons can give you a wealth of information you can use against them. That's not the case today, but we're going to look at it anyway. So I want you to look at the summons. And before I do that, I want to show you what's going to be attached to this video on the membership website, collectionstoppersolutions.com. You'll see the actual lawsuit in this case, and just go look for an S&D lawsuit and see if it applies. The answer and affirmative defense is in Word template, so you can take your states and facts and laws and whatever you're doing, plunk it into that. I have a plunking video. There it is. Plunking video. Whoop. Your counter affidavit template. One of the most important documents in collection self-defense is creating your counter affidavit, which will be in video 5. And then your securitization letter. Whenever you're dealing with a creditor or a debt buyer, I say send the original creditor, even if they're suing you or claim to be the original creditor suing you, or in a debt buying context where they say 6 titles down the road, we bought it from, in this case, HSBC, send HSBC my securitization letter. I'll attach it to this video. Also, securitization letter instructions and my show notes, which I read from in case you don't want to look at this face again. So like, love, and subscribe, and we'll keep bringing the good stuff. Here is the summons page. I don't think there's much here today. There may be in your situation. Shazam. And that is just a breakdown of an average summons, either, in this case, it's Michigan, but they're all the same, really. They have to supply you what's called due process. With a summons, you're being summoned to court, and on the bottom it tells you how many days you have to answer and how many days you have to answer if you receive the lawsuit in a way separate from being personally served, and each state varies, but put that into your calendar first off. So if you're 20 days away from being defaulted, put it in your calendar for 15 days and get that answer, and in between the 1 and the 15th day, do your settlement discussions if that's the way you choose to go. I've got plenty of videos on settling with debt collectors, either before or after they sue you. Shazam. So that's your summons. You check that out, man. There's nothing remarkable here, but you got to keep an eye on your dates and the name in the district, because I've said before, they'll sue you in the wrong district. Now you have a case for money from them. That's automatic, and plus you got a chip now when you're trying to settle or break down your debt. So let's break down the first page of the lawsuit, Shazam. And that is your average S&D or average debt by a lawsuit. They've got their name up there, and you're the defendant, obviously. Make sure they spelled your name right. Make sure it is a complaint for a money judgment. You can see that in the middle there is no other pending or resolved civil act. That's good. That is in conformity with your summons that says, this is the first time we've sued this person. You've seen my videos where, I think it was in one of those 1 to 5 videos where they actually had sued him previously, my client, but didn't tell the court that, and that's against the law in most courts. So if you look at the number 1, remember this is a breach of contract. You can see the words breach of contract. There's no contract attached to this lawsuit. And we're going to touch upon that, what that means and how they screwed that up. But if you see, let's emphasize 1, Shazam. Plaintiff's a Michigan limited liability company with its primary desk. Well, guess what I did? I went and checked it out. And I went to the corporation's website, which is you should always do, of your state and go, let's see who they, it's simple stuff and it's just a brick, it's not a wall, but those bricks add up. If they lied here, they lied there. They know where they are. Why would they put the wrong address? Because they're using no care in their complaints, and that's where you come driving your truck right through the holes that they create and point out, this is just a long line of things that they said, Your Honor, that don't add up, and you're going to see that as we progress through this. So make sure everything is true in these 4 or 5 paragraphs I showed you. Now here's where you're going to be seeking what's called the linchpin of the litigation. I've got plenty of videos on linchpin litigation. I just love saying linchpin because it's so applicable. When you knock out the 1 or 2 paragraphs, the whole thing collapses. It's just a house of cards. Just pull one of the cards out. So you look for the linchpin. So we'll come in there. So let's go to paragraph 5, Shazam. We're just going to emphasize each paragraph for you now. And this is where you can see that HSBC, with a gold MasterCard account, and claiming the defendants are becoming bound by the terms and charges and disclosure. Never heard that, by the way. I don't know what terms and charges disclosure is, but they're in a sense saying that the actual contract that the client signed with, as they say, corresponding account statements are attached at Exhibit 1. So let's go to Exhibit 1, Shazam, and that's it. No, it isn't. That's just an assignment which should be Exhibit 2. They've already screwed it up, but we're going to get to this form of assignment and bill of sale very quickly. But what I want to tell you is they have not attached a contract that they say the terms and conditions of which you've breached have become in default. So that's already sort of a messy screw up on their behalf. As I switch. But let's look at their number. What they claim is Exhibit 2. They claim they have Exhibit 1, which should be the contract, and they've put Exhibit 2 in it instead. I'm not screwing this up. I'm just reporting what they're doing. And so let's look at some of the parts of that and see. Schedule B1, form of assignment, bill of sale, Shazam. And that says nothing. That's really just a forward flow agreement announcement. And if you just go down some of these paragraphs, you can see that this is all based upon a pool of accounts that is getting pushed and shoved somewhere. They claim it's between HSBC and D&F Associates. I see D&F Associates a lot with lawsuits. It's weird to see them in this form and not sue on their own debt. But maybe they wanted to get rid of it as fast as possible, as did HSBC. And what you look, as far as hints of that, you'll see the words without recourse. That usually means here, you take this. That's an as-is relationship. But in this case, they're just saying they're giving a bunch of pools of receivables of accounts without the word debt. I think this may have passed for a complaint. I think there was 11 or 12 paragraphs, and I've never seen so many times the word account used instead of debt, and you all know what that means. But we do not have the terms and conditions and charges disclosure that paragraph 5 says we have, and what you have before you is just a terms and conditions of a purchase agreement or a forward flow agreement. It'll say right in there, this is a purchase agreement. That means it's a forward flow agreement, which they do not attach. And we're going to have some fun with that too. The word debt is not mentioned here. There's just data files that aren't attached. And I'm telling you all of this because this goes in your answer to each one of these paragraphs. This goes into your counter affidavit. Let's look at paragraph 6 of the complaint, Shazam. Defendant defaulted on the terms of the account and failed to repay the obligation. There's no account attached, no account statement, no contract, as I said previously. And again, this is a breach of contract. In Michigan, and many states, if you file a breach of contract action, you have to attach the complaint, or you have to say in your paragraph pleadings, the complaint is in the possession of the defendant. So they say it's a breach of contract, they say it's attached, they don't attach. And by the way, the 3 exhibits they attach aren't numbered, so you're left on your own to figure this out. But that all goes into your counter affidavit. When you look at the counter affidavit in this case, you'll see I've put down all these things that are bricks that are becoming a wall for you. So there are no terms of the account or proof of failure to pay the obligation that anybody's breached. Let's look at number 7, Shazam. So again, I'm showing you pleading 7 and how I answer pleading 7. So they say the original creditor duly assigned, first of all, drives me nuts. Like imagine your fingernails on a chalkboard while you're chewing brick. That's how I feel when I see the word duly assigned. It's either assigned or it isn't. It doesn't need an emphasis or a description of what's happened. It's either assigned or it isn't. Duly, I don't know what duly is because there's no real basis of anybody to assign that is assigning anything here. So I don't know what duly assigned means. They're saying they duly assigned this to DNF Associates as evidenced by number 2. Number 2 is number 1, the exhibit 1, and number 3 is dropped into exhibit 2. This is their stuff. So we're missing the contract and all the exhibits are wrong and not applicable, but I will give you what they claim is exhibit 2, Shazam, and that is DNF sending something to Southern Capital Financial Group, and that again is based upon this agreement, which is the forward flow agreement that they will not give you. But if you're going to say something is breached pursuant to the terms of the agreement, which they do say here, then they must show you that forward flow agreement. By the way, every bill of sale assignment is pursuant to a forward flow agreement from the original creditor to the debt buyer or several debt buyers. No matter if it's LVNV funding, Midland Credit, PRA, Crown Asset, their sales are pursuant to the terms and conditions of a forward flow agreement that you will never see. Tip, ask for it, and that case will get settled. By the way, looking at the bill of sale here in this case, look at that signature. That's another one of those chalkboard moments. It's just, you go check out, find this guy's signature, and you'll be quite surprised that the fruits of your labor will be rewarded. This is somebody signing for somebody. If that's his signature, go find out, but don't leave any brick unturned, any stone unturned. Find out if that's that guy's real signature. Again, no forward flow agreement, and there's a fun thing I'm gonna show you. In fact, I'm gonna bore you purposely now, right? So I'm gonna read to you their bill of sale. Now, therefore, for good valuable consideration and pursuant to the terms and provisions of the agreement that doesn't exist, seller hereby sells, assigns, quit claims, transfers and conveys to buyer all seller's right, title, and interest in and to the receivables. It's a debt, it's not a receivable. And fourth, as set forth in the agreement isn't attached. Provided, however, such transfer is made without any representations, warranties, or recourse, except as provided in the agreements. In other words, again, hold your nose, without recourse. Here, you take this. When you sell something without recourse, you want nothing to do with that. So that tells you what they think of the value of this debt. Any sales tax resulting from the terms of such agreement is the sole and exclusive responsibility of the buyer. The receivables are transferred pursuant hereto are transferred as is, and where is, as more fully set forth in what? The agreement that doesn't exist. So that's my thing about that as is relationship. If you sell someone a car, hey buddy, it's up to you if you're buying it as is, just so we're very clear here. And that's the same mentality when they're getting rid of debt. It sucks, it's bad, you don't want any responsibility for it. So, and neither does my client, and that's why we break this stuff down. I meant to say all that stuff to you to give you instruction, but also to bore the hell out of you, because that is a worthless document that doesn't mean anything. But I want you to look at the meaningfulness of it for you. Look at the bottom of that page. Shazam. DNF Associates, LLC, Account Receivables Purchase Agreement, page 16 or 18 of 18. Hey man, where's the other 17 pages and why are you hiding them? They do silly stuff like that. I used to point that stuff out, then they started whiting out, but then they realized they got to support. They don't care. You take advantage of their inability to care. Where is the rest of the agreement? Where's the 17 pages? And look at that signature, as I said before. There are only 3 exhibits again, but there are 4 exhibits, supposedly. So we looked at paragraph 9, Shazam, and that's now Southern Capital Finance Group is claiming to duly assign and transfer to plaintiff S&D, that's your plaintiff today, investors, all the title, blah, 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 to the account. Again, if it's a debt, why don't you say that? Well, we all know why, because it's been securitized. Again, this is based upon a forward flow agreement that's not actually attached, the receivables purchase agreement. A forward flow agreement is always called the agreement or the receivable purchase agreement, or they actually say sometimes the forward flow agreement, which is cool, but they don't attach, even though everything is pursuant to that, and they haven't added the terms and conditions of that or the actual contract. But let's look at, but there's more. Let's look at the bottom of what they say is Exhibit 4 that doesn't exist, Shazam. And you can see Southern Capital Finance Group, Receivables Purchase Agreement, 11 of 11. Again, there's no pages attached to this lawsuit, no 10 through 11 pages. There's never an accident. There's never an accident when you're being sued for money. It's all purposeful. Don't forget that. So let me just quickly show you 10 and 11 of the complaint, Shazam. And again, your old buddy, the account, has been defaulted. Plaintiff accelerated all amounts due and owing pursuant. Why did they say that? Because if it was a promissory note or something similar to that, the statute of limitations starts when they first ask for all the money owed. Whereas in a credit card agreement, the statute of limitations starts a month after the last time the payment was made. So they throw in that to protect themselves, like you're being sued on a promissory note, which you're not. And they can claim, no, it isn't over the statute of limitations. It starts when we ask for the money. There's no evidence of that. And then look at 11. As of this date, the amount owing to plaintiff from defendant on the account is blah, 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 is reflected in the account statement where the original creditor charged off the balance and closed the account due to non-payment. See Exhibit 1. Doesn't exist. There's no contract. There's no account statement at Exhibit 1. Remember, Exhibit 1 was actually Exhibit 2. So there's no default or proof of any contract. The above responses are put into the answer of your collection response, your defense, your answer and your affirmative defenses. See video 4 of my Examining the Lawsuit series. That above, all this that I just showed you, said to you, and will include in this video attachments at collectionstoppersolutions.com. All that goes into your counter affidavit. That's part 5 of my 5-part series. The counter affidavit is everything. You've seen more videos on the counter affidavit. I probably have done more videos on the counter affidavit. Number 2 would be portfolio recovery. Number 3 would be LV/NV funding. Number 4 would be MCM. And then number 5 would be starting to be the securitization of it all. So that counter affidavit is number 1, and it's going to stay number 1 as far as how many videos are there on our Collection Stopper Solutions website with hundreds, probably, of counter affidavit examples. So go check that out. Anytime you go to our membership website, go immediately to the search bar. Anything you need on that thing, it's really easy. Just go to the search bar. We have a search bar on every single page of our membership website. So we make it as easy as we can. If you want it even easier, please say, hey Parker, why don't you come to my house and do it for me? That's an easy way. We'll consider it, depending on what food you have. But that's as easy as I can make it. And when you lock into that search bar, you'll lock into, what do you got? 290 videos, 1,000 templates, all there. Just one price for as long as you want it. Per month, obviously, but just cancel after a month if you want, but get what you want. We also have deals where you can do 3 months if you wanted a really great deal. But use that search bar. And here's my wonderful expression. I'm going to save that for you because I feel like I'm already selling too much. But you shouldn't be hassled for debt collection until someone proves you actually owe it to them. So that's the basis and tenet of everything I serve upon you. They've got to prove ownership. So use those 5 videos. Use each one to examine the complaint against you the way I showed you today. You'll have a securitization letter on there and instructions how to do that securitization letter for when you go against HSBC. I'll even address it for you. And remember to send it by certified mail, return receipt requested, keep a copy of the signed letter and that green card when it comes back. So I hope we did a good breakdown for you. That's a typical debt buyer lawsuit, S&D Investments. I don't see them much, but they're my guinea pig today for you that you can apply to any debt buyer case. I've got tons of debt buyer cases, MCM, PRA, Crown Asset. I shouldn't sound like I'm being bored. LVNV funding, again, a very popular one. My point in telling you all of that is that you can use a piece of every single one of them. If it doesn't fit your situation, take from here, take from there. With the membership video, again, you've got 290 videos of your choice. Probably take you a month to go through it, but search bar that puppy. Search bar that puppy, all right? So that's it, folks. I hope you have everything you want. Subscribe, like, and love, and we'll keep bringing the good stuff. Thank you very much.